Quickly moving forward, I now request Ms. Neeti Sachdeva, Secretary General MCIA and moderator for session 2, to please come to the stage. I also request Mr. Robert Price, partner at Latham & Watkins, London, to please come to the stage. Mr. Thayanathan Bhaskaran, partner Bhaskaran, Malaysia, please, sir, can you please take your seat? Mr. Mark Rollins, King's Counsel, Keating Chambers, and Mr. Narottam Sharma, Advocate and Techno-Legal Consultant. So please take your seat.
Good afternoon, everybody. I think since I'm representing an arbitral institution, I think the organizers also think it's best to create a problem and then to send it to the institution and then say that finish it now. So that's my mandate, that I have to cut down on this panel from an hour to probably about 40 minutes and then to 35 minutes, but we'll try and get through to all the points that we've discussed. We have a great panel here who have traveled all the way to be a part of this. The topic for our panel today is construction arbitration and its peculiarities, which basically means how to turn a 12-month project into a 4-year arbitration. Sorry, I mean ad hoc arbitration, because institutional arbitration works quicker. Now, construction disputes are a world of their own, and when you have a broad topic like this, I thought to myself till about 3 days back, I don't have to do anything. I will ask the theme to each panelist, what do you think is a peculiarity? And the session will be done. But my panelists were very active, and they initiated a discussion and said we should have some themes. So thank you very much for taking the initiative. So the 4 broad themes that we have today is, first is going to be on the mountain of documents. Because in construction arbitration, if your pleadings don't need a trolley bag, are you even there? The second theme that we are talking about today is multi-tiered arbitration clauses, those beautiful clauses which start with mediation, trend into adjudication, then flirt with expert determination, finally are in arbitration. The fourth topic we have today is to talk about expert witnesses. I don't think we can have a panel on construction without experts and how they should present their claims. Should they be presenting their claims? A good question. And finally, the fourth theme we have for today is the lonely soul in the entire arbitration process, the poor arbitral tribunal. Who has to maneuver through all of this? So we'll see the construction arbitration's peculiarity from an arbitral tribunal itself. Please welcome me in joining my 4 great panelists. I only have an easy task of asking them a question and they run it from there. I'm not going to introduce them in detail, but I'll do tell you one fun fact about each of them. So I'll start with Robert. Robert is an age group cricket player, is what he says, and in India, cricket is a religion. So I thought it's a very good fact for you to have it. Even now, if you speak anything, it doesn't matter when people know you play cricket. He also has an accolade of having in the same session, season 2 hat-tricks. Mark is still looking for his fun fact, and I think he will reach it there once by the time we finish it. Maybe this session is his fun fact. Then we have with us Mr. Narottam Sharma, who is an avid nature trail. So when he's not dealing with the tigers in the arbitration, he's dealing with tigers in Ranthambore. And finally, we have Thaya. I'll call you Thaya. That's easy for me. Who is, of course, reads a lot, given that he's doing construction arbitration. That's not a surprise for me. He swims a little, and he's now learning golf. So with that, now we begin our session, and I will straight away start off with Mr. Sharma to you to say that contracts, drawings, specifications, photographs, snag list, and the list can go on and on. When faced with the massive document repository, what methodology or technology can parties in tribunal leverage to effectively identify and organize the crucial evidence needed in construction?
Construction contracts, as we know, they are different from other disputes that they go, and as you rightly said, involve multiple. Firstly, the construction contract itself, the disputes, they run into years, 3-4 years, voluminous contract documents, voluminous records. And then, of course, the process starts right from the execution stage itself. The because the disputes, they take place during that period. And then there are monthly progress reports, the minutes of meetings, the RFIs, all those. So the strategy has to be finalized and really implemented at that stage itself. What documents to be recorded, to be kept, and what are the information to be recorded there. It has to be finalized right at the inception of the contract itself. So each contract has to be studied at the immediately after award of the contract and finalize the strategy. What are the strategies to be adopted? What records to be maintained? What notices to be issued? Have to be finalized right at the stage of finalizing the contract itself. And then, if proper records and documentations are maintained, then it may make the task easier at the stage of arbitration to really substantiate the disputes, not only on the factual aspects, but on the quantum aspects also. If you have not done that aspect, that part during the course of execution of the contract, then it may become a difficult situation. Because as and when the dispute arises, you have to maintain the contemporaneous record at that point of time, because those records are generated. When you see a possibility of firstly, in general, there are certain records to be kept, and then specific disputes and related documents are to be kept. Then, of course, another aspect which comes is the proving the actual cost incurred. There are two types of costs. One is the direct cost of the plant, equipment, material, which are directly, they can be recorded based on in the monthly progress reports and others. Then there are other costs which are not really visible on the ground, but they are costs incurred. There again, they are recorded in the accounts. So even in that stage also, we have found that there are difficulties in identifying and apportioning the cost, because the cost is booked on the company level. How to apportion it, that is there. So those are, at that stage also, it has to be maintained properly. Then only it will make the task easier for us to substantiate the factual aspect as well as the quantum aspects at the arbitration stage.
Thaya, if you would like to come in there and probably provide your comments very quickly, but I would also add in this that in a typical arbitration construction, what we tend to see is that the claimants will file a voluminous documents. The respondents will probably try and overdo them and file another larger voluminous documents. And then the tribunal will come back and say that, can you please submit your combined bundle of documents, as we call it? And we see that the reliance on the documents is hardly anything. So is there any strategy, technology that you employ for your arbitrations, or anything you want to comment on what Mr. Narottam has just said?
Yeah, so as Narottam mentioned, usually in arbitrations where all the documents have been maintained, you usually end up with a room full of documents, as you mentioned. So the question is how then to make that something digestible for the arbitral tribunal. So in my own experience, I find that visual aids are very useful. So for example, I was recently doing a railway dispute where there were multiple changes to the elevation and alignment of the railway track. And instead of going through each drawing and trying to identify that change, if you simply overlay the drawings, one over the other and visually represent that to the arbitral tribunal, it's easier for the arbitral tribunal to understand how the elevation and alignment of the railway track is shifting with each drawing. So I think these sort of visual aids are very useful in getting through these voluminous bundles of documents.
Right. Thaya, let me just remain with you and come to the next theme of multi-tiered dispute resolution clauses. We see them in the construction industry a lot. Do you see any particular sort of peculiarities in the construction multi-tier contract clauses? Or do you think they're just very similar to what you find in the commercial contracts as well?
I think they're very similar to what we see in commercial contracts. I think what makes it different in construction contracts is just, at least in my own experience, how uniformly across the board they seem to be included in dispute resolution clauses. So in commercial contracts, they are occasionally there, but not as uniformly I think, as in construction contracts, especially at the main contract level, where you almost always see a clause providing for negotiations first, followed by mediation or a DAB, and finally arbitration. Earlier this morning, we have been repeatedly speaking about the FIDIC forms of contract. And of course, the FIDIC form of contract provides for a multi-tier dispute resolution process, with the engineer first determining the matter, then it going to a DAB, and then finally to arbitration. So problems that have arisen in that regard are that when one party, when the claimant tries to skip one of these steps,
yes,
and refer it directly to arbitration. So when that happens, usually the respondent will raise a jurisdictional challenge. And in relation to those jurisdictional challenges, the courts traditionally have taken the position that they will enforce each of these steps, provided that the terms of the contract are sufficiently precise. The courts are quite keen to enforce them on the basis of party autonomy, and because some of these alternative methods may in fact be cheaper than arbitration. But more recently, there has been a sort of shift in some jurisdictions. So in my own home jurisdiction, we still follow the traditional approach, and I think here in India as well. But in Hong Kong and Singapore, there has been a recent shift from the 2020s onwards, where they've sort of drawn a distinction between admissibility and jurisdiction. And the position that has been taken is that unless the multi-tier clause expressly states that each step has to be complied with in order to grant the arbitral tribunal jurisdiction, then the question doesn't go to jurisdiction but just to admissibility. And any decision made by the arbitral tribunal will be final in that regard.
Thank you. Robert, may I just probably bring you in here and see that, do you see in your jurisdiction or in your experience that construction arbitration would usually tend to have multi-tiered arbitration clauses? And like Thaya said, that you have different law emerging out of it. India has a very conservative approach to what maybe Singapore has. What's been your experience and in your country?
Sure, this is actually working. We do see it, I think, certainly in England. I think you don't see in domestic projects quite perhaps such elaborate mechanisms as you see for FIDIC. I think it does, there's quite a variety of practice depending on the sort of place you're talking about. I think another related issue to this jurisdiction versus admissibility issue, which I think has largely been resolved in favor of admissibility, is also the interaction between a multi-tier dispute clause and your ability to access urgent interim relief before the arbitration has commenced. Now, if you've got a multi-tier clause and you're supposed to negotiate for 90 days, but you're only 30 days through, how do you deal with that? Are you still allowed to go, for example, to the emergency arbitrator, bearing in mind that you're supposed to start the arbitration, the main arbitration, pretty much at the same time? Now, I think most emergency arbitrators in the decisions that we have available have sort of resolved this, I think, quite sensibly by saying, well, the time period for filing the main claim, starting the main arbitration is extended, so you don't have to do it within 10 days. You can make it consistent with the clause you have. But there are some court decisions which say, no, we won't, for example, enforce an order of an emergency arbitrator because you didn't comply with a negotiation period. And I think there's another point that needs some quite careful thought, comes up quite a bit in practice, and that's where's the right forum to go for urgent interim relief. In England, we have a slightly troublesome situation, to my mind, where it's not, if the emergency arbitrator, for example, is available, you can't really access the court. What happens as well if you can get some sort of order from a conservatory order from a dispute board? Is there an argument you should be going there? And I think there's perhaps some argument for trying to seek clarity in your dispute resolution clauses to make it very plain that you can still access this form of relief, which is often very important for preserving assets or ensuring work continues on a project, and you don't end up in satellite litigation about the proper process of resolving the dispute. The ability to get interim relief is clear and still available, notwithstanding the benefits you can get from these clauses.
Right. Narottam, would you want to probably comment on from the Indian perspective here and what your experience has been?
Yeah. This morning also there was discussion about this multi-party, multi-tier arbitration. In construction contract, it has got very significant because a point was made in the morning that there should be only, you should avoid multiple arbitration in the same contract. In that sense, especially in construction contract, the pre-arbitral procedure, especially DAB and others, are very important in case, but only thing is that the decision taken during this DAB and others, which are pre-arbitral procedures, those should be given effect. What we have found, all those pre-arbitral procedures have, the recommendation have come, but those recommendations have not been implemented, given effect. So that makes the entire process of the pre-arbitral procedure with all those dispute boards and others totally useless.
With the new Mediation Act that we have in India, are you seeing that in the construction arbitration also as a pre-arbitration process, mediation is picking up, parties do try to make an effort there?
Yet again, mediation is subject to the parties' agreement. Who will decide? From the government side, somebody has to take a decision.
Right.
A call has to be taken. Contrary to arbitration proceedings, those are binding. And mediation again leaves it to the parties to agree or not to agree. And there again the problem, same problem that we are facing in the pre-arbitral procedure, there are dispute board decisions, there are specific provisions in the contract that till such time the dispute is finally decided through arbitration, the dispute board's recommendation shall be given effect. That is to avoid any disruption to the cash flow of the contractor so that the project does not face any problem. But that is not adhered to. Same fate, I fear the same problem with mediation also. Who will take the decision? Even if suppose the mediator has offered a solution which is very beneficial to both the parties or the fair, reasonable, justifiable, still somebody has to take a call on that. And from government side, we will face the same problem that we have today. So I don't know whether it will have any success with that.
We'll see. It's always good to have a positive outlook. I haven't forgotten you, Mark, and I will come to you on a question on that. But you know, as an arbitral tribunal, which is your theme, we always come to the arbitrator on the last word. So I will go to Mark first and bring in the experts. You can hear the expert and then have your verdict on it. Robert, tell me this, that when in a construction arbitration, especially peculiarities of it, if an expert has to present its evidence, what would you say that, what should they be looking at? What should they present? Should they make it more complicated? Or they should try to bring it down to the knowledge of the arbitral tribunal, who may not always be an expert in that field, both from construction and from quantum, if you could comment on.
Well, I think, I think it's usually complex enough. So simplify, I think has to be the mantra. And condense. Make it easy for the arbitrators. They've got enough to be dealing with the vast sort of factual record, 20 witness statements, probably as many expert reports. You do get that in some cases. There's a lot you can say about expert evidence. Some obvious points about, independence, being non-partisan. I think those are fairly obvious points, and you need to choose your expert very carefully and make sure you don't get someone who is just fundamentally argumentative and thinks that they are going to serve you and your client well by essentially taking your side, adopting your case, and not making reasonable concessions when that is necessary. No case is perfect. I try to think about this, as sometimes I find it helpful to think about this in terms of what would I look to undermine in the opposing expert, and try and make sure that my expert is not falling into the same traps. I think something I've seen in a few cases, which again could be avoided, is when you look at the expert report and you see the list of evidence that has been reviewed, and there are quite often surprising gaps, and it leads to a hearing with sort of predictable lines of cross-examination. Mr. X, you seem not to have reviewed X witness statement. No particular reason for not doing so. And then we go to Y witness statement. That hasn't been reviewed either. And the tribunal's eyebrows start to sort of raise. And then you go through various documents which should have reviewed. And there are little nuggets of information that could have had a bearing, or at least should have been considered and then rejected for whatever reason if it didn't change the opinion. And the line of questioning goes on. If I told you it said this, would it change your opinion? And it's, I think, death by 1,000 cuts. It can be very damaging to the credibility, and at the very least, it requires the opposing counsel in closing submissions, whether oral or, taking up a lot of pages in the page-limited post-hearing brief, to try and explain why actually it didn't matter that a lot of those documents didn't need to be reviewed, the witness statements weren't that relevant. But often there are a few things that should have been considered, and I think that's a really important point. The expert evidence is grounded in the facts and the particular circumstances of a project, and if you don't do that in a rigorous way with the expert, you will get into trouble. And the other thing, it was touched on earlier, the sort of presentation. If we're thinking about the theme of simplify, explain, try and be helpful to the tribunal, given it's all difficult enough. One thing I've seen in sort of particularly technical disputes, a case I did for a long time regarding an explosion in a power plant, which was because of mishandling of some electrical switchgear, very complicated, quite bespoke set of gear, very, very old as well. And one thing that our expert did, which I think was very compelling for the tribunal, was they got a replica piece of equipment, they did some 3D printing, and they created this computer graphic that explained how exactly it had been mishandled. It was very firmly grounded in the evidence, the contemporaneous documents, the logs of the handling of the equipment. So it was quite sort of unimpeachable on those grounds. And set against that was the other side's expert, which was just a report. And there were some pictures of the burnt out equipment. But our expert...
To simplify would be to do away with party-appointed experts and just have a tribunal-appointed expert.
You can obviously do that. I would say in my experience, and the people on the panel may have different experiences, I would say I haven't seen too much of that. And I think parties, when they're confronted by it, get a little bit concerned about the loss of control. Is the tribunal-appointed expert essentially going to be a fourth arbitrator? And is it going to lead to, a little bit like a single joint expert, is it actually going to lead to lots of time and cost savings if you're going to do away with party-appointed experts? And I think typically no, because the parties will have their own consulting experts, so you are still going to be spending a lot of money. My personal view is that it can be a reasonable approach, but I think party-appointed experts are generally fine so long as the process is sort of rigorously controlled, and particularly the experts are not ships passing in the night, so you don't have, and it's fine, we know in this area that there are legitimate differences of opinion as to what is the appropriate methodology for something like delay, but the tribunal needs to be there ordering the experts to at least engage with each other's methodology, so it's helpful to them, and you need to have, I think, quite early discussion of what are the real issues between the experts, try and narrow it down as much as possible. You don't want to get to the hearing and find that there are still, wide areas of disagreement, and it's not really clear why.
Right. Thank you. Mark, thank you for your patience. You are the patient arbitrator who sits in the room, listens to every party, and is in his head deciding what he needs to be doing next. Before I go on to the theme of what an arbitrator can do, maybe you want to comment on what Robert just spoke about with respect to experts, and maybe some comments on dealing with the voluminous documents, because you are the one who has to have those voluminous documents in front of you. So any particular strategy while as an arbitrator or as a counsel that you adopt on that?
Thank you very much. Is this working? Yes, it is. Well, I have to say I agree with everything Robert has just said. I think tribunal-appointed experts obviously look good in theory, but in practice end up costing more because the parties will retain their own experts to advise and to prepare cross-examination, if necessary, of the tribunal-appointed expert. So far as practical tips for parties to present expert evidence, again, I'd echo and endorse what Robert has said about early identification of issues. That's crucial. But if I just give 4 or 5 thoughts about that. First of all, appoint the right expert. As you all know, there are lots of experts around looking for work. I hope they don't think I'm being unkind when I say that. Experts are a big investment in a case. They're very important in these big arbitrations. They play a significant role. And it's generally speaking critical that whoever your appointed expert is has some experience of cross-examination. You don't want to be the party for whom this is their first run, their first time at the wicket, as it were. Secondly, obviously, and again I endorse what Robert says, and if they're good, they will know this, but that they know and understand and remain independent, know and understand their duty to be independent and remain independent. Because when I'm acting as fighting counsel in these cases, my job of cross-examination is easiest when I can establish that they're not being independent. At that point, the tribunal will tend to prefer the evidence of the other expert. The third point I'd make is control. Parties need to keep control of their experts with their lawyers. They are a huge part of the cost of a case, and with careful and experienced control of their work, those costs can be kept down. One of the ways of doing that, my 4th point, is early appointment of experts and get them to agree between each other, with the assistance of the tribunal, various matters like the delay methodology to be used, the baseline program that they're going to use, maybe even the windows that they're going to use if it's a windows analysis. If you can get early engagement and agreement on those points, often under the procedural order, the experts, certainly if I'm sitting as an arbitrator, I want to see early engagement and agreement on those issues, because if the experts agree those matters early on, you will save a lot of time and effort and certainly cost down the line. And when it comes to quantum, for example, early agreement about sampling and extrapolation of variations and so on and so forth can help save money in relation to the expert appointment. Very quickly in relation to documents, excuse me, again, it's more of the same really, which is first of all, early identification of issues is really important because, of course, the documents that you require for the arbitration are those which are relevant to the issues. So if you can have a procedure which seeks to identify early on what the relevant issues are, you can focus the need for documents. And again, as I've just said, early identification of delay and quantum issues, so that you're only looking for and trying to organize and present documents which are relevant to the issues between the parties. That is, the things they don't agree about. If they agree about stuff, you're not really going to need documents in relation to those. And similarly, sampling and extrapolation. You don't necessarily, if the parties can agree a sensible process, you don't need to deal with every single variation in the case. You can approach it in a slightly more sophisticated way in an attempt to reduce the time and cost of examining the issues.
Right. Could I then now come to the last theme for the today's session that we have on the arbitrator's perspective when they see these peculiarities in the construction arbitrations? Could you just elucidate some of your examples there? What do you think about it? Maybe beginning from the appointment of an arbitrator itself.
Well, I can keep this genuinely very short because, if I may, I respectfully agree with and adopt the remarks and observations of the Supreme Court Justice Malhotra, who covered this ground in her excellent address far better than I could. And so, if I may also quote and rely upon the authority of Supreme Court Justice Bindal, if I can just cut and paste her remarks, that really gives you what you need to know about the arbitrator's experience of these large arbitrations. I've spent the last 30 years, having said that, I will of course say a few things of my own. I've spent the last 30 years practicing in construction arbitration, and I now do probably about 30% of my work as arbitrator and 70% still as counsel. Just a couple of thoughts. First of all, the arbitrator's point of view, that's what I've been asked to talk about. And it's worth reflecting on, I think, Professor Sundra's observation in his talk, that, of course, it is absolutely right that it's the arbitrator's point of view that matters. And it's worth remembering, talking about construction arbitration and your role in it and preparing cases and so on, that ultimately what matters is the arbitrator's point of view. The second point I'd make, and allied to that, is that probably one of the most valuable parts of my education when it came to the practice of construction arbitration was shadowing and sitting with, as it happened, a TCC judge, a High Court judge practicing construction arbitration, but it's also possible to do it with arbitrators. And it is extraordinary, for those of you who haven't sat as an arbitrator, how different the experience is if you're sitting with the tribunal as opposed to sitting on one of the party sides of the room. It is eye-opening as to what works and what doesn't, and what matters and what doesn't, if you can see it from the tribunal point of view. So I would urge all of you, certainly starting out in practice, but even more senior people, it is worth, if you have a judge who will allow you to shadow them, or if there's some way you can get to sit with a tribunal to watch a case, that will teach you so much about the best way to present cases, because, as I've said, it's the arbitrator's point of view that matters. So far as the peculiarity is concerned, the peculiarity of construction arbitration from an arbitrator's point of view, and dealing with this very shortly, there are two real points. The first, and this has been a theme of various speakers already this morning, is that it's a specialist area of work. These are huge projects, and in most jurisdictions, they have developed their own specialist corpus of law and practice. So from an arbitrator's point of view, if you're not from this world, if you haven't practiced in this world, if you haven't grown up in this world, it's going to be a very steep learning curve indeed, and it's going to be hard work for the counsel and lawyers and parties presenting their case to get you up to speed. So certainly from a party point of view, I think it makes sense to appoint arbitrators who are familiar, at the very least familiar, with the basic terms of art and the basic concepts. The second thing is the peculiarity, again, obviously something that's been touched on, is the enormous and complex projects that are having to be arbitrated very often, certainly in the ICC world, for example, in a relatively short space of time. By their nature, because they're large and they're high value and they're complex, they tend to have eminent and senior arbitrators whose diaries are not open to taking long appointments. So you often have only a couple of weeks to deal with an entire large infrastructure project. So what does that mean, those two points? Well, first of all, it's important to remember the arbitrator is responsible, the arbitrators are responsible for setting the timetable and controlling costs. Most procedural rules, and indeed most arbitral laws, place a duty on arbitrators to deal cost-effectively and efficiently with the arbitrations. And what that means is that from an arbitrator's point of view, you want to be proactive, ideally, and imaginative, and obviously sensible and fair in arriving at a timetable and a process that meets those objectives, i.e. can reach a decision, an enforceable award, cost-effectively and efficiently. So I would say that it's crucial to appoint someone familiar with construction, a tribunal that will be prepared to be proactive in meeting their obligation to deal cost-effectively and efficiently with the dispute, and then obviously a tribunal that is going to be capable of producing an enforceable award, subject obviously to scrutiny by, in the case of the ICC court. So unlike arbitrations in many other fields, there are those peculiar aspects to it that mean, to come back to the starting point, that I think selecting an arbitrator, selecting an appropriate arbitrator, is an important part of ensuring that your dispute is dealt with cost-effectively and efficiently.
Thank you so much, Mark. I think for a second I would drop my moderator hat and probably wear my other hat of an MCIA, and I totally agree with Mark to say that I think construction arbitration, one peculiarity remains is getting the right arbitrator. Of course, it's for other cases as well, but for construction, definitely that is one. And one of his suggestions that people who have an experience in the industry but may not have an experience of being an arbitrator, I think a tribunal secretary comes in as a very handy tool, and now we have courses happening in India where you can do a tribunal secretary, make that transition from going from purely a counsel practice to an arbitrator practice. And that is quite helpful with people who are making that transition. I think there's one more thing which I would touch because I still have about 10 minutes, and I will probably ask all my panelists to answer on this, that in 2015 we had an amendment to the Arbitration Act of India, and one of the major amendment was that we were expected to finish our arbitrations in 12 months, extendable by 6 months with the agreement of the parties, and then you had to go to the court for an extension. And I can tell you that right after that amendment came in, there was a hue and cry to say that, can you really have the pendulum swung from 4 years to 18 months? And I think one of the peculiarities again was for the construction industry, because you have these large volume of matters. Do you think really in that background where legislation tries to reduce the time, institutions try to do that as well, because you want to put the pressure on the arbitral tribunal, you want to put the pressure on the council that finish it up. But do you think with the peculiarities of construction arbitration, is it possible to finish your hearings in just 2 weeks' time? Or is it just something to be discussed in the conferences? Maybe we can begin with you, Mark, and then Robert, if you have any comments on that, and then we'll go to the others. Please, Mark.
I'm going to give the typical and slightly unhelpful lawyer's answer, which it depends. It is possible, but you would need cooperative parties and counsel on both sides and experienced and proactive arbitrators. And then it is possible to deal with even the largest of cases in a relatively short period of time. I mean, to deal with an entire infrastructure project in 18 months would be going some. But certainly with modern technology, which means that obviously document retrieval and searching is much, much quicker, it is possible. But I suspect that most people practicing in our field in relation to a large construction arbitration would say that 18 months, if that's from the referral to final award, that's pretty ambitious, to put it mildly.
Robert, what about you?
I tend to agree with that, and I think one has to remember that in the first few months of an arbitration, it does take a while to get going as the tribunal is constituted. So if you've got 18 months, you're probably losing to some extent the first few anyway, so maybe you're looking at 15 months, and that seems to me a pretty tall order. I think it's good to have sort of ambitious goals, and to some extent, when people talk about the merits of arbitration versus litigation, it's very difficult to say that arbitration is quicker than litigation these days, as you apparently learn in law school. But I do think that also with these sorts of legislative interventions saying, well, you have to go to the court to extend the time period, one has to be a little bit careful with that, because it's a pretty draconian sort of guillotine that's coming down, which will essentially render the entire arbitral process sort of null if the court decides, well, no, we're not going to give you an extension. And there have been laws like that in other parts of the world, and I think largely the sort of direction of travel has been to move away from that. You can have things as the ICC do. You know, there are other ways to motivate people. I think there are ways to motivate the arbitrators as well, quite frankly, by perhaps withholding some of their fees if they're too slow. I prefer things like that to more drastic legislative intervention.
You know, everybody in the room and my panelists can breathe. We don't have that law in that form now. We say that you have to finish your pleadings in 6 months and then the 18-month timeline starts. So there's a breather there as well. But let me come to you, Thaya. What do you think in Malaysia is your experience being? I mean, we as an arbitral institution like to put out our statistics. Alexander is not here, but if he was here, he would have said that at the end of the year, we all want to project we've finished our arbitrations in 18 months timeline. Should there be an exception for construction?
I think it's ambitious for major infrastructure projects, but certainly doable. I say that from two perspectives. One is the experience in Malaysia with statutory adjudication, where the Malaysian experience with statutory adjudication is that by and large final claims have gone for statutory adjudication as opposed to interim claims. and those get wrapped up within 3 months pretty effectively without any hearing. And that has then fed into the practice of construction arbitration in Malaysia, where surprisingly there's actually a push now to reduce the amount of hearing, and council seem to realize that a lot of things can actually just be decided based on the documents. Again, because the documentation in construction projects is becoming ever more sophisticated. Apart from the written records, a lot of construction projects are also entirely audio-visually recorded in totality as well. So you can see what's actually going on at the site at any given moment as well. So I think it's something possible. I think obviously the construction arbitration would need to be a lot more actively managed, perhaps, than what is typically done in an ad hoc arbitration. Echo what was said earlier, perhaps something similar to what's done in ICC arbitrations, where the issues are drawn up and frozen at an early stage, and then parties can't really go out of that. So that keeps you fairly confined and able to resolve the dispute within a reasonable time.
Thank you. Mr. If you have any thoughts, last 1 minute for you to give your thoughts on this.
Definitely can be done, but only thing is it needs cooperation from all dates. How the adjournments are, the times are taken. In any case, the legislation, that amendment, 2015 amendment, at least it has put some pressure. And I can see that there are really improvements in maybe not 18 months, but yes, definitely there is an improvement in the time taken for publishing the resolution of the disputes, definitely.
I agree. It's at least deterred some of the arbitrators who would earlier take on about 50 arbitrations a year to probably just take about 5 and try and finish it. Vyapak in the morning said that one of the people that we need to thank is the participants. And if it's only 5 of us who speak, then there's no point of thanking all of you. So, yes. But not from you, Mr. Singh. No, I will give the opportunity to the ones who have not spoken, and then I'll come to you if they will let me have 2 minutes. Okay, I will. Sorry, if I could just say, you're saying that should we have the tribunal?
Should tribunal ask for relevant documents from the parties? Because generally what we see is parties will not produce the relevant documents. And in US, we call it spoliation, where adverse inferences are drawn. So should tribunal ask for this? Because we are talking about common law jurisdiction where it is adversarial, not inquisitorial in that real sense. So should in arbitration, which has become more inquisitorial now, should tribunal ask the parties to produce the relevant documents?
You can answer it in a yes and no. You don't have to give reasons. We'll take that later.
I know that Ratan would not be satisfied with a simple yes or no answer. Obviously, from my perspective and my background, as you rightly point out, the common law position would be that that's not what the tribunal is there to do, and it's up to the parties to produce whatever documents they want to produce to prove their case, and if they fail to do so, they'll fail on a burden of proof point. I think there's probably a middle ground, which is I've seen adopted and have adopted myself, which is to indicate to the parties. So, for those of you who don't know, obviously quite often in arbitrations, documents are produced pursuant to what's called a red fern schedule, where the parties identify what documents they want to see from the other side, and then the tribunal decide whether or not to grant that disclosure. Is that sometimes the tribunal will observe in relation to a certain class of documents that one party is refusing to produce, that if those documents are not produced, either the tribunal will find it difficult to see how they would succeed on a burden of proof point, or make some other observation in relation to it, falling short of ordering disclosure if the other party doesn't want to give it. But yes, I'm not sure I would really want to get into the realm of trying to work out what documents I want to see for a party to prove its case. I think it's quite an important part of the process that a party needs to identify and produce the documents if it wants to succeed, and if it fails to do that, it doesn't succeed. It keeps the parties honest, I think.
Has any question, no legal advice please, just any question on construction peculiarities. Let's take it. We've already taken one from this table. Can I just take something from there, Pradeep? We anyways will meet for coffee and lunch and you can ask a question. Go ahead.
Good afternoon, everybody. It's very interesting to learn about the construction arbitrations. Unfortunately, in India, you know, I remember one famous word by Dr. Singhvi, Abhishek Singhvi, who was our advocate from NTPC side, and I was the star witness. He said very aptly that arbitration is nothing but pre-litigation litigations, that's all. In the Indian context, we can really say like that, and we have a lot of seminars, we have a lot of this one, but unfortunately we find that real experts who had done the projects, who had been, part and parcel of those works, they do not find a place, you know. We find mostly this one is hijacked by, you know, high court judges, this one and all, which are very, unfortunately in India, you know, these real experts are not given any chance. That's why I think we lag far behind till such time it is
Thank
really...
you. I mean, we were expecting to have a question, but we take your
Yeah,
comment in there.
fine.
I really need to close with this, with the organizers telling me this. So thank you once again for all of you joining us. I hope that your next project finishes on time, under budget, and that you have an arbitration clause which all of you can understand. So if you need to draft one of those, please feel free to come and talk to me. Thank you very much.
Thank you, panelists. I would now request Mr. Vyapak Desai to kindly felicitate the speakers. We would now take a short lunch break and reconvene at 2:45 sharp. So please take your seats at 2:45 sharp.